Good afternoon, everybody, and welcome to the Creative Finance Collective. This is the time we get together and talk about all things creative finance, all things real estate. So if you have questions and you're watching, we're here to answer those questions, and we'll be here as long as we get the questions. So look forward to engaging as we move forward. Today it's going to be Sean and I, and it's going to be us all by ourselves. So we'll manage those questions as we get them just fine. Not too worried about it. Sean, we already have a question. So it's hitting right out of the box on agreements for sale. Question is, can the seller on an agreement for sale assign the agreement similar to the sale by a holder of a promissory note? So, well, I think, get where this is going.
Yeah. Yes, unless the language of the agreement for sale says you can't. So if you put something in there on the agreement for sale that says you can't assign it, then it's likely going to be assignable, or at least assigning the right to, receive payments under the agreement for sale. So yeah, a seller can assign an agreement for sale, and the rights to receive payment under the agreement for sale, similar to a promissory note. Couple of things though that are going to be different. So if you assign a promissory note and you go through the foreclosure process and you record the beneficial interest of a deed of trust, when you go through that foreclosure process, you as the buyer of that note can step in and place a bid, your credit bid, right? And if you're successful on your credit bid, then the trustee will actually execute a deed to you. So other than assigning the note, doing a recorded assignment of beneficial interest of the deed of trust, there's nothing more to do, because if you win with your credit bid, the trustee is going to give you title to the property. Well, it doesn't quite work that way in a forfeiture under an agreement for sale, right? If the buyer doesn't pay under the agreement for sale, then even if you've assigned the agreement for sale and you forfeit the buyer's interest, well, title actually reverts to the original seller, despite the fact that they assigned the agreement for sale to you. If that makes sense.
Yeah.
So in that case, you actually are going to need, in addition to the assignment, you're going to need a warranty deed from the seller that goes to you as the assignee that you can then record to basically, so that when you do forfeit the interest, or if you end up having to forfeit the interest, then title is vested in you as the assignee of that agreement for sale.
That's a lot of deeds held back and not recorded, right?
Yeah,
there's already
although I don't know why you couldn't record. You couldn't record your record your deed as the assignee immediately and just have that out there, because it would be like the after acquired property doctrine would kick in.
Okay, so you go ahead and have that executed, recorded, have that done, and it's never going to be a complete deal from a title officer's perspective until they see that recording of or the
I take that back. You would not want to record that, and the reason is because if the seller performs, you want to make sure that you get that deed from the original, not the seller, the buyer. The purchaser performs, you want to make sure you get that original deed from the seller to the purchaser. So yes, that deed would have to be held and only recorded upon a forfeiture of interest.
Okay. We don't see that transaction.
Yeah,
we don't see that transaction happen all the time. In theory, it doesn't. There's a market for the sale of notes, right?
Right.
And in theory, there's no reason why you couldn't have a market for the sale of agreements for sale. It's just a little bit more complex, I think, on the back end in handing the paperwork.
Right. And I also want to talk about assigning an agreement for sale as the purchaser.
Okay.
And so if the agreement for sale allows for it, then the purchaser can assign the agreement for sale. And in that case, once again, the purchaser would execute a deed in favor of the end buyer, the assignee. They would execute that deed and deliver that to the servicing company. And likewise, on the assignment of the agreement for sale by the seller, you could take that deed and deliver it to the servicing agent. That's the importance, in my view, of having a servicing agent, is they can kind of coordinate, these different assignments and things like that, and they can know, okay, where does the money go now? Those types of things.
Okay. Interesting. All right. If you're just now joining us, this is the Creative Finance Collective. We've got additional questions. If you have a question and you're watching, we're talking about all things real estate and creative finance, and we've got some questions about agreements for sale. Go ahead and post those questions in the chat, or any questions that you have will be on here as long as we're getting questions. I don't really know if this is a related question. Well, it's obviously related as it pertains to agreements for sale, but I don't know if it's necessarily related as to your answer, Sean. But we had another question, which is, what happens if an agreement for sale is not recorded? Because an agreement for sale is an agreement among parties, and in a lot of transactions, right? Most people are told you don't record the promissory note, or you don't record this agreement, or you don't record that. There's a special instrument that is used for the recordation purposes. The agreement for sale, though, is an agreement between the buyer and seller, and is the agreement that is recorded. If that's not recorded, we have a problem, don't we?
Well, you don't have a perfected interest in the property, right? That's the problem. You have an interest, a greater interest in the property as to the seller, but you don't have a greater interest as to anyone that would come after you, and place a lien or make a claim against that property, because you have an unperfected purchase interest in the property.
Yeah. So if you were to jump back to the first question, hey, I'm in the market of buying agreements for sale, for instance, like buying the note, and you find out it's not recorded, or maybe the draft agreement that they get you to, or the agreement they get you to look at, does not have a recorder's stamp on it. Okay, the due diligence needs to start. It should have already started anyway, but it really needs to start in earnest at that point. Would he immediately running a title report?
Well, I wouldn't even jump into that at all. I would just walk away, because clearly, what other issues am I going to, find here? And the second problem is, with not recording, is now you're talking forfeiture judicially as opposed to with notice. And third, without a servicing agent, I have no clue what kind of payments have been made, not been made, how much principal has been paid down, how much. So let's say without a servicing agent in place, let's say I go buy that agreement for sale, or acquire that agreement for sale, and then all of a sudden the purchaser shows up and says, oh, I made a $30,000 principal payment. And they can prove it, and the seller lied to me. Or maybe they can't prove it, but they just allege it.
And the problem is, at that point, if you're not the original seller, you're completely in reliance upon whatever representations that were made to you, and good luck maybe finding them.
Right. And so, the purchaser could say, oh, I showed up with 10 grand cash. Not likely, but nevertheless, it creates a colorable, issue that's going to have to be dealt with. And the only way to really, figure that out is in a court proceeding. So, but a servicer would be like, no, here's our records, here's how we keep track of everything. there's no way they would have shown up with 10 grand in cash and not had that reflected properly on their account, right?
Yeah.
And you're going to win that every time. But, how do you dispute it if, you have a seller who maybe you can't now get a hold of and is, or being difficult, not cooperating?
Right. If you're just not joining us, this is the Creative Finance Collective. Sean and I are taking questions until we stop getting them. So post those questions. We'll be on as long as we get those. We're monitoring the chat. So give them to us. Right now, we're talking about agreements for sale. Sean, it makes me think that, we're talking about the opportunity of buying, somebody who comes in and buys an interest on an agreement for sale and has that assigned to them. And, the problems that would entail whether, if they didn't have a servicer, for instance. A servicer is not required, at least in Arizona, in setting up an agreement for sale. There are certain benefits you receive by having it serviced, but I guess this is a good non-legal point as to why you ought to have a servicer, right? I mean, it directly impacts, I think, what we're really kind of addressing there is it directly impacts the marketability of the agreement for sale as to whether there's a loan servicer, right? I mean, you basically have something nobody would want to buy.
Right. That's exactly right. Or buy at a really steep discount. You really should have a loan servicer, a note servicer in place to, keep track of those payments. Plus, like you said, I mean, foreclosure or forfeiture, you can do it without notice and without going to court. You can't do that in Arizona without.
Yeah, and even if you were inclined to save money and be like, well, okay, my lawyer told me all of that. I'm okay with doing a judicial forfeiture. And whatever else, I don't know who would really want to do that, because the point of the agreement for sale is the ability to quickly get it back if you can. But assuming they were okay with that, most buyers wouldn't be interested in that. They want the quick exit strategy too. So that's gonna, so if the legal reasons to use a servicer aren't enough for you, the marketability of your instrument, you would think, would be enough for you as to why you ought to use a servicer. It just doesn't make any sense at all to not be using a servicer. Another follow-up question on the agreement for sale we have. If the parties are not using a loan servicer, so I guess that would mean the original parties, who holds the deed to the buyer?
Nobody. You get the deed at the time of performance.
Yeah.
So that's another reason why a servicer should be put in place. I don't know about you, Andy, but I've had a handful of title issues that were referred to me by generally title companies where they're trying to close. And, what happens is somebody acquired the property by agreement for sale. They paid it off. They thought they then, were in the free and clear. So they then start conveying it to their family, and maybe it goes through inheritance. Bottom line is, when you figure everything out, title's good with everything, except there was no deed ever recorded to establish performance under the agreement for sale. I mean, and these agreements for sale, I mean, agreements for sale have been around forever.
Yeah.
And so I've seen them from the, 40s, 50s, 60s, 70s, where these families have owned these properties. They thought they performed and they should have title, only to find out that, oh no, like the seller never conveyed title by warranty deed. And
Right.
so we've had to go and track down the, prior owner, or we've had to go and track down the heirs of the prior owner, or whatever the case may be, and be like, hey, they would have performed by now. And if not, you're probably outside of your statute of limitations, or you are outside of your statute of limitations to bring a forfeiture action or other action on the contract. And so, we need you to deed it over. Knock on wood, we've been able to resolve it, but it's a real problem. And, somebody's paying our attorney's fees to get to figure that out. So that is the problem, is you have a seller who, especially if it's subject to, and all you're doing is writing the checks to the lender every month to pay off the loan, and then the loan gets paid off. Well, now you need title, and this seller may be AWOL. You may not be able to find the seller. So now you're stuck doing a quiet title action.
Yeah. So we have a follow-up question to that. Before we get to that, if you're just now joining us, we're taking questions, creative finance questions. Feel free to post them in the chat. We'll be on as long as we're getting them. Follow-up question: what do you have to do legally if a seller won't convey after payment in full? Either, I guess that would be either won't, or in the case that you mentioned, maybe they just can't find them, or they're dead, or whatever else. I mean, what you'd have to really bring an action, right? You'd have to bring a legal action.
Yeah. So an action to quiet title or for specific performance against that party. You're going to probably want to send a nastygram to begin with, a demand letter that basically says, hey, look, you need to perform. If you don't, you're going to be hit with attorney's fees and all these, damages, if I have any, et cetera. You're clouding title to the property now, the whole thing, and send off this letter. And if they still don't perform, then yeah, you're going to have to file a lawsuit and move as quickly as you can through the litigation process to try to put title in your name.
And to your point, it's hard to imagine a scenario where a seller just wouldn't convey. The more likely scenario, I think, is where it's a long term and somebody's died.
Yep.
And in that case, though legally speaking, most lawyers would say, well, okay, we'll get it served somehow and we'll get a default judgment and we'll get there somewhere. But if there's no party to cooperate, you're not ever going to get your fees out of that, right? I mean, that's all going to be sunk costs. You're going to be into this thing a while.
Right. That's number one. You're not going to probably be able to recover costs. Number two, to your point, you have to name a party. You can't just name an estate. Or if you name the estate, you have to serve the estate. Well, if there is no pending estate, who do you serve, right?
Yeah.
And so, if somebody dies, the agreement for sale should be an asset of the estate that then gets distributed to the heirs, similar to the very first question. Can you assign an agreement for sale? Yeah, it would be assigned to the heirs through the estate process. And then they should record a notice of assignment of agreement for sale to, these particular parties, it's signed by the personal representative of the estate. And now the heirs own it. And then you should be able to just go to the heirs and be like, hey, give me that deed. And then you should be good to go. But you and I both know, number one, there's a lot of good probate attorneys out there, but there's not a lot of probate attorneys that really understand real estate, and in particular, how an agreement for sale is going to operate, right?
Yeah, well, and not only that, the process of trying to get a personal representative appointed on an old estate with a deceased owner that's not been around a while is not as easy as it sounds. I mean, first of all, assuming you find the people in line to act as the personal representative, imagine how that conversation goes. It's real easy to get a PR appointed when you let the estate know that, hey, we found $1 million that belongs to you. We just need to write a check to the personal representative of the estate. Right. They're all running to the courthouse to get appointed.
Right.
But when there's no money going to them and the obligation, it's just a demand that an obligation come back to you. How interested is anybody to go, spend their time uncompensated to go do that?
Right. Yeah, they're not going to want to cooperate at all.
No.
And frankly, you as the, owner or, party that performed under the agreement for sale, essentially you're going to have to foot the bill to make it happen. And then hopefully they're at least willing to give their time to do it. Now, you and I have both done this, and it's a pain because the judges hate it. But in theory, you're a creditor of the estate at that point. So if nobody will cooperate, you can go and get yourself appointed and then serve yourself with the lawsuit. But judges hate that, right? I mean, they just, even though it's allowed by statute, they just cringe at the idea of appointing a creditor over an estate.
They do. Yeah, you may be forced to have to do that. And then if you're forced to have to do that, not only are you investing a bunch of your own money to get this fixed, now it's your own time
Right,
to close out somebody else's estate just so you can do this.
right.
So, yeah, I mean, as a practical matter, that's just a nightmare. All this story leading all back to whether really you should have a servicer,
Right.
right?
Yes.
Don't do it without a servicer.
Right, because that problem's solved with the servicer in place.
I know. And how much money are we really talking about saving? It's not that much.
It's like $30 a month, something like that. I mean, it's not much at all.
Yeah. 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 So if there's any lesson in the discussion we've been having in questions in the last 25 minutes, it's get a servicer and look at the form your form agreement for sale on the assignment provision to make
Right.
sure it has that ability. That would be makes me wonder, I haven't really searched this, whether there is some sort of marketplace for the purchasing of agreements for sale. I can't imagine,
I
but
don't know.
that'd be pretty interesting. Maybe there should be. Well, if you're just now joining us, this is the Creative Finance Collective. We're taking questions, so if you have them, post them. We haven't had a question here in the last few minutes, so if we don't get them, we close it out. So yeah. Anything else going on in the world of creative finance?
Not really in the world of creative finance. I know unfortunately, we don't have our Texas folks on because I think there's a lot going on in Texas right now with, potential or pending legislation that I would have liked to have inquired
Oh,
about.
they've got statewide legislation that's
Yeah, I
pending.
think so. So next Tuesday, hopefully we'll have one of our Texas attorneys on who can, give us some input on that. But otherwise, yeah, nothing major that's happening.
All right, good stuff. Well, that's all the questions we've got.
Yeah.
Those were good questions. Good topic to work through. With that, we'll close it out.
All right.
Join us next week, and we'll talk about. We'll inquire with the Texas folks on what they're dealing with over there in terms of creative finance and other legislation.